This video series is brought to you by the Legal Department of the South Carolina Victim Assistance Network. We're a nonprofit organization that assists with the enforcement of crime victim rights and support services.
There are several legal terms used to describe sexual crimes in South Carolina, but you do not need to worry about those technical terms. Generally, if there was unwanted force used, or if you did not give consent for the sexual act, a crime may have been committed. There only has to be physical contact, however slight, into your private areas for it to qualify. It can include oral sex, penetration with a body part or other object, or sexual intercourse. Sexual assault also includes unwanted touching of your private parts or forcing you to touch the offender's private parts. Private parts include the genitals, anal area, and buttocks. Breasts are considered private parts for females. There is a common misconception that most sexual assaults are perpetrated by a stranger of the victim. However, this is not true. Most sexual assaults are committed by a person known to the victim. The offender could be a friend or acquaintance of the victim, a parent, sibling, or other relative of the victim, a coworker, classmate, or caretaker of the victim, or an intimate partner, spouse, or boyfriend or girlfriend of the victim. South Carolina does recognize sexual assault between spouses. The law in South Carolina is called spousal sexual battery. If the spouses are living together and not estranged, then the sexual assault must be reported to law enforcement within 30 days of the offense. In addition to this timeline requirement, the law requires that the offender either used or threatened the use of a weapon or used or threatened the use of physical force or physical violence that caused or could have caused serious physical injury to the victim. Inappropriate touching or groping absent some type of penetration would not qualify as an offense under this particular law. Just because the parties may have been sexually intimate at one point during a relationship does not mean that consent is universally given. A victim has the right to say no at any time. Sometimes these types of sexual assaults can make for more difficult investigations and prosecutions for the victim because a lack of consent would have to be proved despite consent having occurred on prior occasions. However, difficult does not mean impossible, and many intimate partner sexual assaults have been successfully investigated and prosecuted.
Often the process to report a sexual offense starts with a medical exam at the hospital, followed by reporting to law enforcement, and then the case may proceed to criminal prosecution. Keep in mind that the process can vary depending on the nature of the sexual assault against you. Some people begin by reporting to law enforcement first, and the medical exam may or may not be needed, depending again on the circumstances of the sexual assault itself. South Carolina does not have a statute of limitations. This means that a sexual assault can be reported years after it takes place. However, keep in mind that the sooner the sexual assault is reported, the more likely that the case can be properly and successfully investigated and prosecuted. Law enforcement is better able to collect evidence shortly after the offense.
This video is not intended to provide individual legal assistance or advice. You should contact an attorney for your specific situation if you have legal needs resulting from an assault. Also, while much of this process is the same regardless of which state you live in, our office is located in South Carolina. This video is based on the laws and procedure within South Carolina and may differ from other states. For more information about our victim assistance services, call 803-750-1200 or visit www.scvanlegal.org.